And last Friday we had lawyer Kevin Venditoli for the Stonehouse, again talking about there's a legal back and forth between folks in the town and this entity which had weddings scheduled that were actually canceled by lieu of a decision made by a judge. And now we've heard from Kevin. We have Bill Landry, the lawyer for the group Preserve a Little Compton around the corner, who is going to come in and we'll ask him a few questions about representing the group.
Okay.
Bill, thanks for coming in today.
My pleasure.
I appreciate it. As I said, we had Kevin on last Friday. Wanted to have you on representing the group Preserve Little Compton. Now, as we talked about, you've been representing them for quite some time now.
Since the spring of 2016, before the last season.
So why were you brought in? Let's go through the motions.
Well, there was great concern by neighborhood residents that what was being planned for the Stonehouse in terms of weddings and special events was not consistent with local zoning requirements, that certain processes needed to be followed and stipulations needed to be added to their proposals. And we became involved in trying to move these matters before the zoning board as far back as the spring of 2016.
And who exactly is involved with this? Do we know the folks who are involved with Preserve Little Compton?
Well, the party that was directly involved in the litigation before Judge Van Coogan, the hearing that took place for several weeks during June of this year, was Lisa Clive, and she's a direct abutter of the Stonehouse and has legal standing to assert positions with respect to that property. I do represent a broader group, of which she is one, named Preserve Little Compton. That's a group of supporters of the town. Many of them are residents, and a high number are property owners in the direct vicinity of the Stonehouse.
So talk with us again. We had seen what transpired last week. Some folks might have known that there was some back and forth going on. Again, we saw these weddings ultimately canceled for the upcoming season. What are the battles over? We've heard about the parking lot. We've heard about the entertainment license. What exactly are the legal battles?
Well, there's a core overarching legal issue that's been on the table since last spring, and that is what are the grandfathered rights associated with this property? It's a commercial use in a residential zone, and commercial uses are lawful to the extent that they were lawfully established when zoning came into Little Compton in May of 1968. So the underlying legal issue for the past 2 years has been getting at what was the scope of the use of this property for special events as of May 13th, 1968. That's the issue the court spent more than 3 weeks trying to get to the bottom of, with the assistance of many witnesses, exhibits, legal briefs, and argument.
So how did new owners then come in and say, we're going to hold kind of big, spectacular weddings here, and feel that they were sort of, quote unquote, entitled under the auspices of the law to do so, and then find ourselves at the juncture that we're at today?
Well, I'm not sure how they came to that conclusion before they began their operations, but it was very clear as of last fall that the town was not going to grant an entertainment license for the 2017 season unless and until the Stonehouse owners addressed these issues before the zoning board or sought some type of determination in the Superior Court with respect to what their alleged grandfather rights were. Town council told them that last October. The zoning officer gave them an opinion to that effect last November. The council told them that again in February, and the council told them that again in April. And at each of those meetings, the neighbors were present, wanting to cooperate in a process before the zoning board, a regular process where these issues could get determined definitively and where the scope of the use of the property could get defined and reduced to writing and be part of something that everyone would know about and work within moving forward, including the neighborhood residents. There was no attempt to stop weddings altogether or other special events. There was an attempt to rein them in and have them proceed within the scope of the applicable local regulations.
Now, there's some other private entities down in Little Compton. Take a Secana Vineyards, if you will. How does those differ? I mean, what's their entertainment license like compared to a Stonehouse?
Well, the vineyard is also a pre-existing non-conforming use. They also have agricultural aspects of their use that makes it a little different than the Stone House, but they were issued a license this year, as I understand it, for a number of wedding events, including concerts, and up to 14 weddings. And they did that by getting some relief from the zoning board with respect to parking issues. They satisfied the council, they got a license. They did what they were told to do back in the fall. The Stone House owners, on the other hand, did none of that and were operating until the week before last without a license at this location and without the required zoning approvals.
Now, you've been involved with these sort of town gown issues before, working with the Newport Preservation Society, with the breakers there. Now, were you on the side of the breakers, the Newport Preservation Society in that instance?
Yes, I was.
So talk to us a little bit about that. That caught so much attention last summer. Now, that was some neighbors that were against the visitor center at the breakers, but you represented the Preservation Society side of that.
Yes, I did.
Are there any parallels between the two?
Not really, and I'm not sure that was a town gown dispute. Those were residents of the Bellevue Avenue area taking issue with certain of the activities that were taking place in the Bellevue Avenue area, and I don't think that's comparable. I don't see this as a town gown issue here. I don't see my clients wearing a gown. They're normal people. Many of the members of the group are simply residents of the area. They're not property owners. They're people that are interested in preserving the character and the scope of intensity in the area, including the commercial use. They like the Stone House. They like the tap room. They always like going to the tap room. They like having it available for local events. There's not an awful lot to choose from on Sakana Point in terms of restaurants. They want to see the property remain open. They love the property, but what it's been the past 2 years is that everybody that lives in the area, it's as if they're at every one of these weddings. They're outdoor events with amplified entertainment being operated in a way the court has determined was well in excess of what the historic grandfather rights are that are associated with the property. And again, it's truly as if all of Sakana Point is doing the chicken dance at the same time on Friday nights, on Saturday nights. Huge tents go up there. They remain there for weeks at a time. There's no lawful parking. The judge made specific findings that there was no legal parking there, and that zoning relief was required for that in a real plan compliant with zoning. There was a finding that traffic circulation was a threat to public safety through the course of last year's events. The traffic lanes were blocked, pathways for emergency vehicles were blocked. These were issues of great concern to the governance of the town and to its residents.
So is there any way to, work with the existing owners? Do the Preserve Little Compton not want weddings there altogether? You mentioned keeping it commercial, keeping the tap room. Is there sort of any middle ground?
Oh, absolutely. In the spring of 2016, in behalf of my clients, we made a written proposal to support an effort by the Stone House to add to the barn where weddings have been conducted historically indoors, to add an addition to the barn for sound attenuation that would permit larger weddings that the barn is not capable of holding, and to do so without harmful effects on the entire surrounding neighborhood. And for reasons that are not clear to me, but that I could speculate on, the Stone House operators chose not to proceed before the zoning board. And that's what the court found was the reason for the fire drill that occurred here the week before last, that they were put on notice months and months ago to try to avoid a fire drill and get these issues resolved. They chose not to do that. They didn't notify their customers according to the court's findings and the testimony, and begin to make arrangements for alternate locations until June of this year, when the wedding season was already underway.
So I guess legally, technically speaking, what happens now? Whose court is the ball in? We saw the weddings canceled. What next?
Well, the ball is still in the court of the Stone House owners, as it's been for many, many months, and that is that they have a pre-existing non-conforming use, that to the extent they want to continue to have outdoor weddings with amplified entertainment and special events that require parking beyond what's required by the restaurant and the tap room and the inn itself, that they need to present a plan. The neighbors need to be able to see that plan, the town officials need to be able to review that plan, and they need a license. They need an entertainment license that follows those zoning approvals, so there can be a regular process here, and so that events at some kind of point are not merely being dictated by the owners, the inn owners' business preferences.
Are you surprised at the level of attention being paid to what has transpired down there in the last few weeks? You know, it's been in the news over the, as you said, you've been with Preserve RI since 2016. I'm sorry, Preserve Little Compton. Are you shocked at this level of interest?
Well, I'm not shocked. I am a little surprised that so many people have registered surprise that there is a need for and has been a need and a well-known need for the Stonehouse owners to get their act in order to be able to conduct weddings. Anyone who had followed these proceedings closely would know that that issue has been out there front and center for almost a year, and that the reason why Little Compton requires the entertainment license process to start in October is so that people can resolve these issues before May and before these types of things have a chance to happen. And it's not the court's fault that those arrangements weren't made. It's not the neighbors' fault, and it's certainly not the town's fault that ultimately occurred. It's a tragedy. Nobody in my client group is happy about the prospect of weddings being rearranged. We're very pleased that it appears that most, if not all, of the weddings have been relocated to other venues, lawful venues, including the Vineyard, and that pleases everyone. No one wants to see families be inconvenienced in that way at such an important time, but at the same time, the court was sympathetic to that. The Justice of the Supreme Court that reviewed a motion to stay was sympathetic about that, but at the end of the day, both judges concluded that the rule of law applies, and just like you can't drive without a license, you can't conduct a major commercial enterprise without one either.
Well, I'm sure we'll continue to see more coming out of Little Compton with what's going on down there right now. What folks have seen about in the news, again, last Friday, we had Kevin Venditulli with the Stonehouse Inn and Bill Landry with Preserve Little Compton Inn today. I appreciate your time.
Okay, thank you.
Walking through the issues. I'm sure we'll talk soon. Okay, thank you, Bill. Take care. Bill Landry, lawyer for Preserve Little Compton. This is the group of residents who have been raising concerns about the weddings taking place at the Stonehouse Inn in Little Compton. Again, we had Kevin Venditulli there on Friday here in studio talking about that impact as folks had seen weddings were canceled.